direct contempt proceeding with respect to Deborah Cave, C-A-V-E, as a result of a disruption that Ms. Cave made during the closing argument in phase 2 of the sentencing hearing in the case of People of the State of Colorado versus James Egan Holmes, case number 12 CR 1522, and specifically it was during Mr. Brockler's closing argument. Rule 107 of the Colorado Rules of Civil Procedure defines contempt as follows in subsection A1. Disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings. Behavior that obstructs the administration of justice, disobedience, or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designed as contempt by the statutes or these rules. Subsection B of the same rule defines subsection A2 defines direct contempt as follows. Contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection B of the same rule states the following. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record or in writing, reciting the facts constituting the contempt, including a description of the person's conduct, a finding that the conduct was so extreme that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. In the case of in re marriage of Sir and K, and that's CYR, 186 Pacific 3rd, 88, a Colorado Court of Appeals case from 2008, the court spoke as follows. Rule 107 of the Colorado Rules of Civil Procedure distinguishes between two types of contempt, direct and indirect, and defines the actions constituting contempt to include disobedience by any person to any lawful order of the court. Thus, to find a party in contempt, the fact finder must find that the contemner did not comply with a lawful order of the court. The duty to comply arises because the contemner was aware of the order. Punitive sanctions are criminal in nature and are designed to punish by unconditional fine, fixed sentence of imprisonment, or both, for conduct that is found to be offensive to the authority and dignity of the court. Because the purpose is to punish, and the power to punish for contempt should be used sparingly, the contemner's mental state of willful disobedience must be shown. An act is willful if it is done voluntarily, knowingly, and with conscious regard for the consequences of one's conduct. Punitive sanctions for contempt must be supported by findings of fact establishing beyond a reasonable doubt, number one, the existence of a lawful order of the court, number two, the contemner's knowledge of the order, number three, the contemner's ability to comply with the order, and number four, the contemner's willful refusal to comply with the order. In People versus Aleem, A-L-E-E-M, that's cited at 149 Pacific 3rd, 765, that's a case from the Colorado Supreme Court from 2007. The court said that in cases of direct contempt, our rules of civil procedure require the trial court to warn a person to stop disruptive behavior unless that person's conduct is so extreme that no warning is necessary. Hence, absent a prior warning, a court may hold a person in direct contempt for extreme behavior or for behavior that has been repeated despite the court's warning to desist. So let me address the four requirements that I spoke about earlier from the case of in re marriage of Sir and K. Again, that's CYR. Number one, the question is whether the existence, there's a lawful order of the court, whether a lawful order of the court exists. The answer here is clearly yes, no question about it. Not only is there an order of the court, Order D79, but there is a summary of that order in a big poster outside the courtroom. There is also a summary of that order posted on each and every seat in the courtroom so that people who are sitting in the gallery can read the note that stares them right in their face, the note that's right in front of their face. And here's what it says. All of the signs say the following: spectators must observe proper courtroom decorum. Pursuant to Order D79, audible comments and emotional displays or outbursts, as well as the display of insignias, symbols, pictures, clothing, or any other items that may influence the jury or which are intended to convey a message about a person, an issue, or cause are strictly prohibited. If at any time during the proceedings you feel the onset of an emotional reaction that may violate the court's order, please quietly and discreetly exit the courtroom. Any violators of this order will be subject to contempt proceedings and sanctions and may be barred from the trial. So the first requirement is met. The second requirement is whether the contemptor had knowledge of the order. Well, as I said, there is a sign posted outside the courtroom with the language that I just read. Additionally, that language appears on the back of each seat in the courtroom, and it's visible to everyone sitting in the courtroom and specifically in the gallery. Additionally, I know that at my request, the Sheriff's Department actually handed Ms. Cave a copy of Order D79. I believe it was on Monday of this week, and specifically spoke to her about the need to comply with my order. So the second requirement in terms of her knowledge of the order is clearly met. Number three is the contemptor's ability to comply with the order. I know that the sheriffs had some concerns about Ms. Cave and spoke with her, not only on Friday, last Friday, when she did not arrive too late to be present in the proceedings, but also on Monday before she entered the proceedings, gave her a copy of my order and made sure she understood that she was going to have to comply with that order and able to comply with that order. She has been here Monday, Tuesday, and Wednesday of this week, and she has complied with my order without a single problem. No disruptions, no outbursts, no audible comments, no problems. So I find that she clearly has the ability to comply with my order. And the fourth requirement is whether the contemptor willfully refused to comply with the order. She complied with my order on Monday, Tuesday, and Wednesday without any problems. When the sheriff gave her the order on Monday, there was no indication that she couldn't comply with it or that she had the inability to do so. Today, when we have a courtroom full of people, much more full than it's been on Monday, Tuesday, and Wednesday, and when there's more exposure because there's closing argument, she did not comply with my order. I find that under the circumstances here that this was clearly willful disregard for my order, a willful violation of my order, a willful refusal to comply with my order. I find that Ms. K voluntarily, knowingly, and with conscious regard for the consequences of her conduct, she disregarded my order. She waited until Thursday when the courtroom was full, when there would be the most exposure, there would be the most media here, and she waited until the time when she wanted to disrupt the proceedings. And for the record, part of what she said during the disruption was to utter her disagreement with Mr. Brockler's closing arguments, with what he was saying. Part of what she said is something along the lines of that it wasn't true, that it is mental illness. So I find that this was willful. The question then is whether it is appropriate for me to take action without a warning. And again, the law in Colorado says that Our rules of civil procedure require the trial court to warn a person to stop disruptive behavior unless that person's conduct is so extreme that no warning is necessary. Absent a prior warning, the court may hold a person in direct contempt for extreme behavior or for behavior that has been repeated despite the court's warning to desist. In this case, there was no warning to desist, but clearly there was a knowledge of the order. Clearly there was a willful disregard of my order. And this was as disruptive conduct as I have ever seen. Not only did this individual make audible comments, she actually stepped over a couple of rows in the gallery, maybe more than a couple of rows, as she attempted to make her way toward the well in the courtroom. She also attempted to elude the sheriff's deputies when they tried to get a hold of her. And in fact, it took 2 or 3 of them as she was kicking and screaming to get her out of the courtroom. More disruptive behavior I cannot possibly fathom. And she did it in the middle of a closing argument at phase 2 of a sentencing hearing in a death penalty case that started 7 months ago. This is precisely the kind of situation that not only allows the court to act summarily, but requires the court to do so. And so, based on all that, I find that she is in direct contempt of my orders, and I find that I need to summarily act. And so I'm going to give you a chance now, ma'am, if you wish, to make a statement in mitigation. Is there something that you would like to say that you would like me to consider before I decide what sanction to impose?
Yes, sir.
Go ahead.
I tried to make my statement in May of 2013 when I filed a amicus curiae motion and you all denied it. And then I've been harassed by the police. I was harassed on Friday, Monday, and Tuesday of being here. You can check the video in the hallway, everything. They blackmailed me, made me show my ID. They let me in your courtroom with electronic if I showed them the ID. Then they didn't want to let me wear a California shirt, just picking on me, needling away, trying to provoke me, asking me all kinds of questions. Where are you from? What are you doing here? Why this? Why that? I said, please quit talking to me. I even turned my back on the wall, went to the bathroom, I went outside. Every time, both of them interrogated me on each day. And I come in here, and even a stranger this morning, all kinds of strangers interrogate me. Why are you here? Who do you know? What are you doing here? You know, why are people approaching me like this? I tried to tell the court. I filed a motion for amicus curiae. You all denied it. I sent Jim letters. I sent him cards when this first happened, and all the cards went through. And then I sent a picture of me to him, and the police returned it. Why? He's got a whole wall full of pictures. Why'd they return it to me? Then they started doing stuff like sending my letters back and stuff, and sending these forms, but no reason. There was it was just different stuff. But I tried to do this properly, and you all denied my motion.
All right, thank you, ma'am. I think I forgot to make one other finding, and that is that Ms. Cave's conduct was offensive to the authority and dignity of the court.
And I apologize.
And I appreciate the apology, but it doesn't remedy the situation.
Yes, sir.
What you did was extremely serious and extremely improper, and it is extremely offensive to the authority and dignity of the court. This is not about me, but this is about the court. And my job in this direct contempt proceeding is to defend the dignity of the court, especially in a proceeding that is being broadcast and that is being viewed by as many people as this one is.
Well, then the court should have dignity of humanity and not have a death penalty. It offends me as a human being that other human beings kill each other legally.
All right, ma'am. Thank you for that. At this time, the sanction that I'm going to impose is 3 weeks in the Arapahoe County Jail. Take her away, Sheriff. Thank you.
Y'all just going to create 12 more murderers. Murder.
Thank you.
You can't justify murder with murder. And he said.
All right, this concludes the direct proceedings with respect to Deborah Cave for her disruption during the closing arguments in the case of People of the State of Colorado versus James Egan Holmes, case number 12 CR 1522. Thank you. The court will be in recess.
All rise.